Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 83. This week the three cases we're looking at, the first is an ECJ decision on the scope of the definition of redundancy in the EU Collective Redundancy Directive. Secondly, there's a High Court decision dealing with bonuses in the light of recent case law on contractual discretion and how this should be read in the context of the court being asked to determine whether a bonus had been fairly and properly granted. Thirdly, we've got another ECJ decision, this time looking at calculating annual leave entitlement in relation to part-time workers. So, first case, I'm going to get this wrong, I know, the title of this, Puyanti Rivera and Gestora clubs. This is an ECJ decision in relation to the definition of the term, as I say, redundancy in the European Collective Redundancy Directive. And the key question in respect of English law, UK law, was whether the definition of redundancy includes resignations following an employer's unilateral variation of the essential terms of an employee's employment contract. The background is that the directive requires employers contemplating collective redundancies to consult with employee representatives in good time with a view to reaching an agreement. Collective redundancy, redundancy is defined in the directive as a dismissal by an employer for one or more reasons not related to the individual workers concerned. And the directive sets out two tests to calculate the number of relevant redundancies in order to see if this obligation to consult collectively is actually triggered. And in the UK, as we know, we opted for a test which says that employers need to collectively consult if over a 90-day period at least 20 workers are contemplated or proposed to be made collectively redundant at one establishment. And this is in TULCRA, of course, the TULCRA Trade Union Labour Relations Consolidation Act 1992. The case in question that we're going to talk about is a referral from a Spanish court, but it's clear that the ECJ's decision on the definition of redundancy has an impact in the UK as well. Background facts, and slightly simplified, is that Mr. Puyanti Rivera was employed by Gestora, and between 16th and 26th September 2013, Gestora terminated the contracts of 10 of its employees, one of which was the claimant, Mr. Rivera. Gestora did not collectively consult because it claimed that the relevant threshold in the directive, as implemented in Spain, had not been triggered. However, during the period, Gestora also made a number of other dismissals which were deemed by Spanish law to be at the request of the individual. This was because in one case the employee was facing a 25% reduction in her salary, and she chose not to continue the employment relationship. Following this, Mr. Puyanti Rivera brought proceedings, and his main argument was the redundancies were invalid because there was no collective consultation. Clearly that's a Spanish legal point. But he claimed that the additional terminations in the same period also amounted to collective redundancies, and therefore, when aggregated with the dismissals that Gestora admitted were collective redundancies, the threshold in the directive would have been reached. Gestora argued the individual who terminated her own contract as a result of the change to her salary could not be said to be made redundant under the definition in the directive. Spanish court stays the proceedings, makes a reference to the ECJ. And although a number of questions are put up, I'm just going to focus on this one for the purpose of the podcast. So that key question, just so we're clear, is whether the directive covers the termination of an employment contract initiated by an employee, but a result of a unilateral change to the contract that's been made by the employer to the essential terms of the employee's contract. Well, the ECJ held the directive must be interpreted as covering the situation where an employer unilaterally and to the detriment of the employee makes significant changes to the essential elements of his or her employment contract for reasons not related to the individual employee. The ECJ was unequivocal that on the facts of this case, the employer had forced a unilateral decision to reduce the wages of the employee, and the termination resulted from the individual not accepting that reduction. The ECJ placed significant emphasis on the background to the directive, which was about affording greater protection to workers in the event of collective redundancies. As such, it contended that a narrow definition of redundancy was not appropriate as it would not further the aims of the directive. Well, if you read the decision, you'll see the reason is pretty thin. It's largely policy-driven. There's no really compelling rationale put up by the ECJ. Be that as it may, it is the decision. So I think this is a significant case because it confirms the definition of redundancy under the directive has a wide meaning and that this is an EU definition. It's not something that can be overridden by national law. It certainly can't be narrowed. Position under UK law was already clear that the definition of redundancy included a situation where the employer changed the employee's terms of employment through termination and re-engagement. However, this case has gone one step further and potentially opens the door for further challenges. And I think this case is going to give rise to a number of potential problems for employers. Certainly something you're going to have to think about very carefully. For example, employers may believe they are just short in the UK of triggering collective redundancy consultation because they're proposing to dismiss only, say, 19 employees. Not that uncommon for an employer to want to go up to the line but not over it. However, if there's a relevant constructive dismissal claim which was activated in the 90 days leading up to the proposed departure date for the 19 employees who were redundant, or indeed if one occurs during the redundancy consultation period, then this too could tip the numbers into the territory where collective consultation is required. Separately, it's going to be easier for an employer to overlook an employee who's asserting constructive dismissal and leave them out of the collective consultation arrangements. But if they count for the purposes of collective redundancy consultation, then the fact that their dismissal arises from a different set of circumstances is not going to take them outside the duty to have collective consultation. And this problem is really quite stark, because if you think about it, an employer rarely sets out with a proposal to constructively dismiss an employee. What tends to happen is the employer proposes a course of action, the employee resigns and claims constructive dismissal, and this is subsequently and retrospectively upheld by the tribunal, at which point, of course, it's too late to do any consultation. As we all know, criminal law now plays a part in this area of the law, and there are at least two cases we know of prosecutions being faced by employers, or certainly being started by employers, on the grounds that there had been a failure to submit appropriate and timely HR1 forms. Perhaps this case is a really good example of why it's manifestly unsuitable to have criminal law sanctions in this particular area of the law. So, anyway, the obvious advice is an employer is going to have to tread much more carefully and look closely at whether or not it has triggered the duty to collectively consult, taking into account constructive dismissals, and bearing in mind that constructive dismissals might arise during a process. Do, however, note that not all constructive dismissal claims will bring the employee within the ambit of collective redundancy consultation. The ECJ was very clear that the constructive dismissal claim needs to be brought about by something unconnected with the individual themselves. So, a constructive dismissal claim brought about by, for example, bullying an employee because they're not working hard enough would not be caught. I did wonder at one point whether this situation might mean that contractual relocation clauses were problematic. At the moment, if you're relocating a group of employees in reliance on an express contractual clause, there's no need to consult because all you're doing is applying a contractual power. I did wonder whether now this could be portrayed as making a change to the essential elements of the employment contract for reasons not related to the individual employee, i.e. you want a group of employees who work in London to go to Manchester and your contract allows you to make them do that. However, I still think on balance that falls outside the ambit even of this case because there would not have been a dismissal, constructive or otherwise, and English law requires there to be a dismissal proposed or envisaged, contemplated, whatever, in order for collective consultation to be triggered. So that's the case of Puyanti Rivera and Gestora Clubs and others. Next case, Paturel and DB Group Services UK Limited. This case is a High Court case that was heard in the Queen's Bench Division. We only have a summary of the decision, but I picked the case up for today's podcast as it's a further case dealing with discretionary compensation, and it provides useful guidance and helpful guidance for employers on how the courts deal with bonuses that are either guaranteed or discretionary, particularly in the light of the Wednesbury test and the BP and Braganza case that we looked at in an earlier podcast, all of which builds on the guidance coming out of the Commerzbank and Keene case dealing with contractual discretion. Background was that Mr. Paturel filed a claim against the bank for breach of contract. The claim was filed some months before he and one other of his colleagues were dismissed in April 2015. Paturel was seeking damages for breach of contract in relation to annual bonuses back in 2008-9. Paturel was a trader in a global finance department, and he claimed that, during his recruitment, he'd been informed that bonuses were never less than 5% of the profits earned by the bank by the individual employee. However, Paturel's employment contract told a different story. Contractually, it said he was entitled to a discretionary bonus only, and a portion of this discretionary bonus would be decided in a manner that was to be consistent with how his peers were compensated, but the bank could also take into account other relevant factors. 2008-2009, Paturel received bonuses that were roughly 1% of the profits earned. Contrastingly, he said, two of his colleagues received bonuses which were 8 and 11% of their profits earned. However, those employees, it became clear, had expressed provisions in their employment contracts providing for the calculation of their bonus amounts. Paturel alleged that after the bonuses were awarded, he was then misled by the bank as to the reasons for their award size. Well, following his dismissal, he issues a claim against the bank for damages in respect to the loss of a larger bonus. In his damages claim, he argued that the bank had broken its contractual requirement that bonuses would be determined in a manner broadly consistent with his peers, that's the contractual term, had breached the implied duty of good faith by irrationally awarding bonuses to other employees on a different basis. Thirdly, it had breached the duty of mutual trust and confidence by misleading him as to the reasons for the award size. And 4, breached his reasonable expectation following pre-employment discussions about a 5% minimum bonus. Fifthly, it had taken an inequitable approach to the payment of bonuses by paying large bonuses to some employees and effectively reducing the size of the bonus pool available for bonus payments to the other employees. The bank then applied to the High Court for summary judgment against him for the claim to be struck out on the grounds it had no reasonable prospect of success. Well, the case follows a trend, recent, maybe overstating it, but a trend recently in case law relating to legal principles applying to the operation of discretionary powers, in particular bonus schemes. I think it's fair to say that recent decisions have very much shown the courts are reluctant to involve themselves in setting bonuses and intervening in the mechanics of incentive schemes. Coming to its decision in this case, the High Court referenced the recent decision of Commerzbank and Keene, which the Court of Appeal had held that where the employee alleges the employer's exercise of discretion in relation to bonus awards is irrational, the burden of proof is on the employee to evidence this irrationality. And this has to be established before the employer is required to justify its decision, making it harder for employees to establish their case. However, if the employer cannot justify its actions, this could amount to a breach of the implied term of mutual trust and confidence, and the employee could resign and claim constructive dismissal and compensation for that, or it may, and of course it may result in their restrictive covenants being unenforceable, but it is open to the courts to award damages for the loss of a bonus in those circumstances. In the Paturel case, however, the High Court concluded it had not shown that the bank had breached a contractual term in exercising its discretion. Therefore, the first test from the guidance set out in Commerzbank and Keene was not satisfied. Additionally, the wording that actually was in his employment contract did not support his case. The contractual requirement to determine a portion of his bonus in accordance with his peers was understood to mean those with whom he was on a similar compensation level with, as opposed to simply those on the same trading desk as him. High Court also recognised that the contractual discretionary provision allowed the bank to take account of any other relevant factors when determining Paturel's bonus. Its employee handbook helpfully listed some other factors, and importantly, expressly set out that there was no contractual entitlement to an award, and it was defined as being discretionary. In the light of this, the High Court concluded the bank's reasons for awarding bonuses of significantly different amounts to the two colleagues were sound because those employees were not in a discretionary scheme. Their entitlements were contractual. The High Court also looked at the impact of the BP and Braganza case. Following that case, a party exercising contractual discretion must ensure that it does not act irrationally in exercising that discretion, and that they have taken into account all relevant factors when coming to their decision, and no irrelevant ones. This could require sufficiently cogent proof from the employer to be provided to evidence this. Here, the High Court held that Mr. Paturel's particular claim did not allege in reality that there had been a Wednesbury irrationality error, and the courts could only intervene where this has been asserted. Anne Paturel had claimed that the bank had acted irrationally in paying the other two colleagues excessive bonuses, but given that they had been contractual entitlements, it was okay for them to be treated differently to Paturel. Finally, of course, there was no causal link between the bank allegedly misleading Paturel after the bonuses had been paid and any loss that he had suffered beforehand when the bonuses were decided. The High Court therefore concluded that Paturel's employment contract superseded prior verbal offers. This was reinforced by the custom and practice in the commercial environment. No promises or guarantees had been made to him, and there was no breach of contract by reason of the bank's decision to pay its bonuses in this way. On that basis, the claim was struck out. So, the case doesn't establish any new principle of law, but it is a helpful case to illustrate the general principles the courts have established in relation to bonus schemes and, in particular, discretionary powers under those bonus schemes. Further demonstrates the court's reluctance to involve itself in setting bonuses. It highlights that employers who do not have in place clear bonus schemes can make life much easier for themselves by putting in place clear bonus schemes, rules, factors, etc. Although this case and Commerzbank make it hard for an employee to demonstrate an irrational exercise of discretion by an employer, and show the circumstances in which the court will involve itself in bonus arrangements to be limited, case law makes it clear that an employer still needs to have justification, have justifiable reasons in mind when exercising its discretion, and clear contractual provisions dealing with the discretionary aspects. Interestingly, the High Court here commented that the Wednesbury test had arisen in relation to public authorities. Public authorities, it pointed out, have a duty by law to act in the public interest. That was not necessarily the case with private sector bodies, in this case private sector employers. So there's just a line there that indicates there may be some scope in the future to argue that the Wednesbury test does not apply in full to private sector employers. And I don't think this point was argued directly in the BP and Braganza case, which looked at different aspects of the Wednesbury test. But it may be a useful point to bear in mind if you find yourself in dispute. So that's the Paturel case for discretionary bonuses. Third and final case that I wanted to mention is the Greenfield and the Care Bureau Limited, at last, a case name that I know how to pronounce. This is it's a seasonal case because it deals with holidays. It's an ECJ decision which considers whether an employer has to retrospectively recalculate a worker's annual leave entitlement when a part-time worker increases their hours. As a brief legal background, in the UK, under Regulations 13 and 13A of the Working Time Regs, a worker is entitled to 5.6 weeks annual leave each year. That's a full-time worker. Under the EU law framework on part-time workers, there is, in general terms, a pro rata principle, which means that a part-time worker should receive the same annual leave proportionally as a full-time worker. Background facts are that Ms. Greenfield was employed as a part-time worker by the Care Bureau from 2009 to 2013. Under her contract, her working hours varied. In 1 year, she took holiday leave during July. She took 7 days off. Her entitlement to leave at that point was calculated on the date that leave was taken, based on her working pattern for the 12-week period prior to her leave. Therefore, the leave that Ms. Greenfield had taken in July was calculated in accordance with her working hours in the period from April to June. During that period, she'd work 1 day a week. As a result, the time off that Ms. Greenfield had in July had exhausted all of this prorated annual leave allowance up to that point in time. Nonetheless, later on, in August that month, and it's 2012 just for reference, August 2012, Ms. Greenfield increased her working hours. In November, she asked for a week's annual leave, but this request was rejected because the Care Bureau explained she'd already exhausted her annual leave entitlement early in the year, and she'd not accumulated enough annual leave during the period of increased hours to enable her to take a week's leave. Well, Ms. Greenfield brought a claim in the Employment Tribunal, arguing that she should be paid in lieu of the leave that the Care Bureau had refused to allow her to take. The Tribunal agreed with Ms. Greenfield. The Care Bureau applied to the Tribunal to ask it to reconsider its judgment. As a result, the Tribunal revoked its decision and made a reference to the ECJ. The main question was whether the pro rata principle under the EU framework on part-time work meant that the UK working time regulations had to be interpreted as requiring a worker's accrued annual leave entitlement to be retrospectively recalculated when their working hours increased. Meanwhile, the ECJ held that a worker's annual leave entitlement had to be calculated on the basis of the contractual working pattern of the worker, i.e., it had to be based on the number of hours days actually worked in the given period. Therefore, if a part-time worker increases his or her hours, an employer is not obliged to recalculate the worker's annual leave entitlement retrospectively for previous periods, even if those accrued days, holiday, are taken after the working hours have been increased. Obviously, the employer will need to draw a line under the amount of annual leave already accrued, because it should then calculate the annual leave going forward on the basis of the increased working hours. In addition, the ECJ pointed out that the calculation of annual leave entitlement is the same regardless of whether the employment has terminated or is continuing. Well, key point to take away is the not exactly astounding one, that where there are different periods of different working patterns in respect of a worker, the employer will need to make sure that it calculates the correct amount of annual leave entitlement based on the number of hours worked in each given period. A new calculation must be performed for any period in which working time is increased or decreased. I think this is a welcome decision for employers, as it confirms the correct approach in relation to calculation of annual leave entitlement for part-time workers, and that approach for once is pretty straightforward. I don't think the outcome of this case is in any way surprising, especially given an earlier ECJ ruling that a move from full-time to part-time work should not affect the amount of annual leave already accrued. So this is the converse situation, and that also clearly should be true. So that's the case of Greenfield and the Care Bureau Limited. So just a little bit of housekeeping, if I may. First of all, don't forget, this is available on iTunes, the Mayorbound intranet, on YouTube, and on Twitter. On Twitter as well, Nicholas Robertson at Nicholas, Rober, and then the numbers 1 and 1. We also post out the links to the cases where links exist. We will have a normal podcast in a couple of weeks' time, but at some point around that, I'm planning on doing a top 10 employment cases from 2015. No absolute requirement for those to have been on the podcast before. If you think that the most important case, as indeed someone has suggested to me, so someone asked me over Twitter whether I was going to cover the llama handler case and the fight between the two women over the llama handler, which resulted in an employment tribunal case, which got reported in the papers the other day, in fact, I saw. So if you think that's an important case, tell you what, why don't you write in? Let me know if you've got any particular cases you think are important. All the more so, actually, if you think that any of these cases I should have looked at and picked up on the podcast, but haven't. I'll be really interested to hear from you. Do let me know. As I say, I don't think we're going to be doing that in less than 2 weeks' time, but probably I'll be putting the podcast together in about 2 weeks' time. So let's say it's a week today, a week tomorrow, from the time of this podcast going out, and then I'll be able to put together a list of cases for the next podcast, best of 2015. I'll spare you my impersonation of a Top of Pops music and do a countdown 10 to 1, and the Christmas number 1, of course. So that's that, and I think the only other thing is, of course, to say thank you very much indeed for listening, as always. It's much appreciated, and to confirm that no employees were harmed or mistreated in any way in the making of this podcast. Thanks very much indeed.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.